Welcome,
afternoon.
Judge McDonald. Let you get ready there.
Okay. Thank you.
We welcome you this afternoon to appear before the commission, and we're ready to hear your opening remarks.
Thank you, Justice Wiggins and Commissioners. I'm honored to have the opportunity to appear before you today. Let me begin first by thanking you for your service on the Nominating Commission. It is an important public service. Not every state selects judges the way that we do. And although not every state does it this way, I believe our system is the best system for recruiting and selecting judges. That system has proven its value over time. Iowa is consistently ranked highly for the quality of its judges and for its court system in general. And in large part, I think that's due to your efforts as a commission in sorting through the applications, interviewing the candidates, and then nominating those persons best qualified to serve based on their merit and their ability to do the work. With respect to my application, I would humbly submit to you that based on experience, temperament, and character, I have the ability to carry on the tradition of excellence for which our Supreme Court is known. And I would ask that you favorably consider my application for the position. Let me first begin with experience. For years, I've had the honor and the privilege of serving as a judge on the Iowa Court of Appeals. In that capacity, I've performed the core function of a Supreme Court justice, which is deciding appellate cases and writing appellate opinions. In the last 5 years, I've had the opportunity to author approximately 600 opinions and vote on approximately 1,200 additional cases where I served as a panel member. In addition, while working on the Court of Appeals, I've demonstrated the ability to work in a multi-member decision-making body. Both skills, writing and working collectively as a group, are critically important in the service of the Supreme Court. In addition to my work on the Court of Appeals, I believe I have other experiences that would be of value in service on the Supreme Court. I'd like to highlight my district court experience, and I think this is critically important. When Justice Zager retires, there will be one Supreme Court justice who has prior district court experience. And in my view, the Supreme Court reviews the work of district courts. And I think it important that there be a critical mass of justices who have had prior experience on the district court. I think that would better inform the court's work. It would enhance the legitimacy of the court with the bench and the bar. And I believe it would generally instill a greater appreciation for the hard work that our district court judges do across the state. I would submit to you in my application materials, I've identified the rest of my qualifications and experience, and I don't want to go through all of them today in the interest of time. But I would say that as a commission, you need not speculate on what kind of justice I would be. I have a track record, and over the last 6 years, you've seen my work product as a judicial officer in the state of Iowa, and I think it demonstrates a commitment to quality and the fair and impartial administration of justice. I'd like to talk briefly about temperament, and the ability to do the work is critically important, and I think we would all agree having the right temperament is equally important. And when we talk about temperament, we usually talk about things like dignity and respect and integrity, and I think those are important and necessary qualifications for the position. But I would also want to talk about something that's not frequently talked about, and that's humility. And in my view, humility is essential to the judicial function. Both personal humility, being able as a judge to say, I don't know the answer to this question, but I'll do the research and find out. Going to your staff and being inquisitive and being open and receptive to their views and the views of your colleagues. I also think it important that the judge have institutional humility. And by that I mean a judge should be respectful of the limited role that courts play in a democratic society. That requires respect for the separation of powers and adherence to the rule of law. And I would submit that over the course of my career, I've demonstrated the appropriate judicial temperament, both at the district court and on the Court of Appeals, and I would continue to do so if I were appointed to the position. Finally, I'd like to share with you a little bit about my background that may not be in the application materials. And I'm a private person by nature, and I think as an Iowan, the thing I hate talking about most is myself, so I'm going to give it a go and do my best. But my grandfather served in the Navy in World War II. My father was a high school dropout. He left high school, I think right in the middle of his senior year, to join the United States Army. He served 2 tours of duty in Vietnam, where he met and married my mother. My grandfather on my mother's side worked for the South Vietnamese government, and I was born in Bangkok during the war, and after the fall of Saigon, we left the country and came back to the United States. I spent most of my formative years or younger years in a small military base in Göppingen, West Germany, prior to the unification of the 2 Germanys, on a small town, not dissimilar to many small towns across the state of Iowa. And I really enjoyed it. I loved it. I loved the patriotism and the pageantry. Every day began with the reveille and ended with the retreat, which is the raising and the lowering of the flag. And I also loved the people on base. And I didn't know it at the time because it was the only thing I'd ever known growing up in a military base. But the Army is a remarkable melting pot. You know, our friends and our neighbors were of all races and ethnicities, and it was just a wonderful experience and a place to grow up. After that, after we left Germany, we came to the United States as I was ready to enter junior high school in Des Moines. And things changed in our family circumstances. My parents separated and divorced. I ended up staying with my mother, and we lost our home, and she started working a lot to try to make ends meet. And when I was old enough to do so, I did the same. And there were tough times. We were scrambling, but they were not bad times. I generally recall them as being very good times. For example, I remember a time when we went to the courthouse, and my mother was sworn in as an American citizen. And I know for her, it was one of the proudest days of her life. Maybe the happiest day. She probably wouldn't admit that to me and my brother, but she was gifted an American flag and a pocket copy of the Constitution that she's kept for all these years since then. I also remember when my grandparents on my mother's side were finally able to emigrate here from Vietnam, and it was certainly an ordeal for them. I think it took about 15 years of kind of bureaucratic processes and those kinds of things. And on the way, they were housed in refugee camps in Thailand and the Philippines before they were able to arrive. But when they did arrive, they were able to stay with us, and it was a wonderful experience because my brother and I were able to talk to them and learn about their life stories and experiences. So I shared all that with you, I guess, for the purpose of trying to better inform you about my character and my beliefs and the way I think about life and the law generally. And I would say this, I have no agenda in applying for this position, and I have no platform. And although I do not have an agenda or a platform, I do have beliefs and values shaped by my life experience. And I'm an Army brat. I'm a soldier's son. I'm an immigrant's son. My parents were simple people. They were patriots, and they believed in simple values: equality, freedom, justice, and the rule of law. And my father, on his side, literally enlisted and traveled around the world to fight for and defend those values. And my mother's family traveled all the way around the world just to live here so they could experience them. And as a judge, it's a very powerful thing to be raised in a family where people appreciate those values. So those are my values and my commitments. I think those commitments are expressed in the oath of office, which I've had the good fortune to take on 2 different occasions, and that's to uphold and defend the Constitution of the United States and the state of Iowa, and to administer justice equally to the rich and to the poor, and to do so impartially without fear, favor, affection, or hope of reward. And I'm applying for this position, excuse me. I'm applying for this position because I seek to take the oath of office for a 3rd time and continue to serve the citizens of the state of Iowa in a different capacity. So I thank you for your time. I'm going to be open to any questions that you have.
Thank you, Judge McDonald. Mr. Gray, do you have any questions?
I do, Your
Can
Honor.
you grab the microphone for us?
Judge McDonald, we interviewed you 5 years ago, I think,
You did?
And at that time, you've shown us that you have done a fine job as a Court of Appeals judge.
Thank you.
Why do you wish to move from the Court of Appeals to the Iowa Supreme Court? And because of all the administration issues that involve the Iowa Supreme Court, can you talk about how you might address those?
Certainly. I think my motivations for applying to the Supreme Court are expressed in my application, and I view the position not necessarily as a higher position, but a different position that requires a different skill set, and that requires, substantive decision-making ability and concerns for process, administrative concerns, and then public outreach concerns of being the face of the judicial branch. And I think also in sharing my personal story with you, I'm motivated to do that just because of some core beliefs that I have about the rule of law and freedom and justice. With respect to the administrative issues, one of the advantages of being on the Court of Appeals is we are largely removed or relieved of administrative responsibilities. We do have internal administrative responsibilities, but in the past, I've have pretty significant administrative responsibilities, both as corporate counsel and dealing with staff issues and budgeting and those types of things, and then running a fairly significant nonprofit organization where I was responsible for fundraising, public outreach, communicating with government and non-government business leaders, proposing policies, implementing them, executing them, and then monitoring the results that we got from that. If you had specific questions about particular administrative issues, I'd be happy to answer those as well, Commissioner. Okay, thank you.
Mr. Horbach?
Thank you, Justice Wiggins. There will be, your heritage kind of spawned this question. I'm thinking you had so many experiences in your life, and so you've developed an opinion and a great demeanor, by the way. But there's sometimes written law is going to have to trump an opinion. You're going to come into that case in the Supreme Court. How will you deal with that, and are you prepared for that?
Thank you for the question. I think that's absolutely correct. As judges, we've taken an oath to fairly and impartially apply the law. And I'd like to say that we are servants of the law and not its masters. And when a case is presented to me on appeal, I go through the record and I go do my legal research and see what result should come from that, rather than trying to find a result and working my way backwards. And quite frequently as judges, we are writing opinions or deciding cases in ways where we may disagree with the substantive underlying policy, whether that is a piece of legislation, a statute, or a regulation, and we have to set those aside. Our role is not to implement our policy choices, it's to effectuate the law as written in our organic documents and in our legislation. Thank you.
Ms. O'Brien?
No questions.
Mrs. Roberts?
Thank you, Justice Wiggins, and thank you for being here today.
Thank you.
Our legal system can be pretty complicated. Tell me how you work to make the process and your opinion that you've written understandable to those involved.
Thank you for the question. I guess I'll take a step back and just talk a little bit about kind of what I do in terms of appellate writing and how I think that addresses the accessibility issue you're talking about. When I think about good appellate writing, and the thing I talk to kind of our staff about is just some general principles. And the overarching principle is that we write opinions for the losers. We have an adversarial process, and there are winners and there are losers. And we try to do our best to write an opinion that explains to a party why they may have lost a particular case. And in doing that, we emphasize clarity. So both clarity in our choice of language and making sure that we're using terms that are accessible without losing legal meaning, and clarity in terms of the reasoning in our opinions. So that way when an attorney sits down with a client, they can clearly say, here's the opinion and here are the reasons why you lost, and we may agree or disagree with that, but at least they know. We talk about things like brevity, to make sure that our opinions are understandable and accessible and people don't get lost in them. We talk about integrity in our opinions, and by that I mean integrity to the law. As I said earlier to Commissioner Horbach's question, my intent in writing an opinion is to accurately state the law to the best of my ability, and not to try to twist it to reach a result that I would prefer. And more important, integrity to the record and the facts. And I can tell you that, in my opinion at least, nothing makes a litigant more dissatisfied with a result than misstatements of facts and misstatements of the record. And you could imagine, for example, if you were a litigant in a custody proceeding, and in our opinion, we indicated the child's name was John, and it's actually Jack or Joe. To the party who loses that case, they come away feeling like the court's not paying attention, that they're not paying enough attention to my matter. They can't even get the name of the child right. So that's critically important in my view. And then we also write with empathy. You know, that some of these cases we get are very sensitive. They involve family proceedings. And in my view, I don't think we need to include unnecessary facts that would disparage or hurt people's reputation or opinions with their other family members or people in their communities. You know, in a divorce case, someday a child may be able to access an opinion or a decree. And if there aren't things that need to be in the opinion to make it persuasive, then we try to exclude those. I hope that answers your question.
Ms. Connor?
No questions.
Mr. Bloom?
No questions.
Mr. Goodman?
Judge, thank you for your application and your service. I think you're the only candidate that has served both on the district court and the Court of Appeals. And I have heard from many applicants that really to be qualified for this position and judge judges and the proceedings that come before them, you first must be a judge that sits in that seat. That may be true or it may not be true, but I'd like to know what your view of that is and what you've learned as a district court judge that you now see differently as a Court of Appeals judge, and how you have changed your role as a judge. And I'm not too concerned about what's similar, because those similarities are easy to pick out about judges, but what is dissimilar and different? What is the gear change between being a district court judge and an appellate court judge?
Certainly, thank you for your question. The first thing I would say is that having served as a district court judge, you come to appreciate that there is a lot of play in the joints, so to speak. That there are a lot of decisions that district court judges make on the spot, frequently without adequate time to prepare or have briefing on the issue. And district court judges do the best that they can under the circumstances presented with the information they have. And I take that experience with me to the appellate court. And so when I think about reviewing the work of district court judges, I try to be respectful of their work, of their discretionary calls, of their sentencing decisions, for example, or their alimony awards, or whatever the issue is, understanding that there are certain things that district court judges see in person that we don't necessarily see on the record. And they're making calls at the best they can do under the circumstances. So that's one thing I've learned and one approach that I've taken. I would say the primary difference really is, in terms of the work product, is as an appellate court judge, we are writing a different style of legal writing, essentially. As appellate court judges, we have a responsibility to do justice in the individual case and make sure we're looking at the merits of the case. But we also have responsibilities to think of the next case and the precedent that we may or may not be setting. And we have institutional concerns that we have to think about. You know, what is the impact of our case on the citizens of Iowa, the other branches of government, and our district court judges and people who work in our district courts, and what is the practical consequence of what we do. And that's a very different form of writing, and it's a different thought process, I think. And as a district court judge, you're trying to make findings and you're trying to make your orders as complete and as thorough as possible to withstand appellate review and for the parties. So it's a little bit different concept. And I'm not sure if that fully answered your question or exactly answered your question.
It does. Thank you very much.
Mr. Sukup? Ms. Diekma?
Yes. Thank you, Judge McDonald. What I would like to have you address for the commission is that you have a very expansive resume. You've done a lot of really broad depth of your practice. However, you went from a federal court clerk to a very large law firm, to another very large law firm, to the judiciary. And I'd like you to talk to the commission a little bit how you feel you could relate to maybe a lot of the Iowans who don't have that experience, who have not been at the top law firm, maybe been in a smaller county courthouse, and how you would relate to that.
Sure. I feel very fortunate to have worked at the places that I've worked. I did well in school, and that one thing leads to another, and you become a federal clerk, and I pursued that career path because that was where my interests lied. And I also had a young and growing family that I had financial commitments to, and I was very proud of the work that I did at both law firms. I think we had outstanding clients. When I was at Faegre, it was a kind of a larger client, and when I was at the Bellin Law Firm, our typical client was a family-owned business. And many of those in rural Iowa. And so I think my practice, kind of my day-to-day practice, certainly at Bellin, dealt with those kinds of issues, dealing with lawyers in smaller communities and dealing with family-owned businesses throughout rural Iowa and kind of the issues they faced and dealt with. The second thing I would say is I think it important to distinguish between the role of an advocate and the role of a judge. And certainly as a lawyer, I had my clients and I did my best to zealously represent them. But my clients don't necessarily define my worldview or who I am as a person. And I grew up in a small town and then in Des Moines. I still have relatives in rural Iowa. My wife grew up in Akron and graduated from Sioux City. So I understand kind of those issues. And I would say this finally, that coming from the practice that I did come from, doesn't mean that I can't be sensitive to issues relating to kind of rural-urban split or large firm, small firm split. And I think one of my writing samples, the Hoffman case, is kind of indicative of that. So that case was a custody case, and kind of the dispositive issue really was the difference in the quality of the schools between the Southeast Polk School District, which is from a large urban area, and the quality of schools in the Albia Community School District. And I wrote the opinion for our court indicating that that was not a legitimate consideration for the district court. And the thought process behind that was that we are not going to punish parents who choose to leave a large urban area and reside in a small rural area with a custody decision that's adverse to them. And I think there are a lot of cases that I've authored that demonstrate that sensitivity to that kind of split between urban and rural and big firm, small firm.
Thank you.
Mrs. Sinclair? Mr. Bevel?
Judge McDonald, you shared a story with me about a police stop from your younger days.
Okay.
And today you mentioned your beliefs and our beliefs and values being shaped by our experience. That police stop, how did that shape your values?
I wasn't expecting to talk about that publicly, but believe it or not, there was a time when I was younger and I had a lot more hair than I do today. And it was the fashion at the time for young people, or at least some young people, to wear their hair really embarrassed me here, Commissioner.
It's the only time I'm gonna get it.
To wear their hair in braids or cornrows. And I chose to adopt that fashion, and I had, hair that was braided. And one day I was driving with my mother here in central Iowa, a darker complected person with braided hair and kind of, I guess, what you would typically, I think, would be perceived as a African-American hairstyle at that time. That's certainly where the trend came from. And we were pulled over by a police officer who approached the passenger side where I was sitting with his gun drawn and was shouting at me to get out of the car, and put my hands up on the side of the car. My mother was terrified. She couldn't understand what was going on. And the officer said that he believed that I was either assaulting her or trying to carjack her, and that was his perception of the situation of us driving around. So I do not at all compare that single experience to what many people, what may happen to many people on a more regular basis. But I would say that it was a scary moment, certainly. And two, it shaped the way I view police-citizen encounters, and I'm certainly more sensitive to the needs or the realities, I guess, of some of these types of situations. And I think you've seen in the work that I've done in my private life with the Asian Alliance, working with lower income communities, racial minority communities, that I do have a deep concern about substantive justice issues and racial justice issues.
I'm sorry we're out of time here, so I apologize to the group on the right, but thank you very much for
Thank you.
your appearance today, and I wish you the best of luck.
Thank you. I appreciate your time.